Okay, someone asked me what happens if someone is denied a quick and speedy trial. Okay, so I copied and pasted the question to my search engine. Okay, what happens to someone if they're denied a quick and speedy trial? And I came up with the law. I mean, I knew this, but, it's better I show you on the internet the law itself than me just preaching it to you like I used to back in the 80s. Okay, dismissal is the only remedy for denial of a defendant's Sixth Amendment speedy trial right. Strunk versus United States, 412 U.S. 434 439-40, 1973. The sole remedy for violation of a speedy trial right is dismissal of the charges. Betterman versus Montana. Okay. So all you got to do is just Google quick and speedy trial, and if you're still in that state, then the requirements on that will come anywhere between 90 days and 120 days. Okay, so now you have that right, but your lawyer's not going to bring it up, the state's attorney is not going to bring it up, and the judge is not going to bring it up, especially if you don't. But if you know the statute of limitations on a quick and speedy trial, which is basically around 90 days, and that's from the point of arrest where the paperwork is first trial, where you're signed a court date, and I mentioned about a probable cause hearing, it should usually start there. I've helped a lot of people get their cases thrown out on a probable cause hearing first day. Okay, so but if you go to trial and it doesn't proceed in the scheduled amount of time guaranteed to you by the speedy trial, your speedy trial right, then they have to throw it out. And I mean, this goes for people sitting in prison, there are people in lockup waiting for their case to go to trial. There's no excuse for not having a quick and speedy trial. And they'll say that just in criminal cases, but that's not true, because if you read the rules of professional conduct, diligence is a requirement in every case. Okay, that's a rule, which is a law. Expediting litigation is a rule, which is a law. Okay, competence is a rule, which is a law. Communication is a rule, which is a law. So it would be competent if they communicated diligence in expediting litigation in every case. Okay, so just quick 4 rules I threw at you, 4 laws. So you are actually entitled to a quick and speedy trial, no matter what court you're in, as long as you know the law. But nobody's going to bring this up. Okay, so that's why I'm bringing it up to you, okay? You could slap that on a writ of habeas corpus. Look that up. It's self-explanatory. Motion to quash. Okay, motion to quash. And that'll go back to the court where your case started. And what are they going to do? Deny? They took 2 years to give you a trial. You were denied a quick and speedy trial. Okay, it says right here. I'm just pointing out the law, okay? I didn't write this. Look, it says 1973. I was just a kid at the time. That was before I found the rules of professional conduct. What could be the outcome if prosecutor failed to meet the quick and speedy trial requirement? When defendant's right to a speedy trial has been violated as a result of an extensive delay, the defendant can file a motion to dismiss due to the lack of a speedy prosecution. These motions are commonly referred to as certain motions after the 1985 California Supreme Court decision. Okay, what are the 4 factors in court used to determine whether the defendant has been denied a speedy trial? Determining whether or not been denied his right to a speedy trial under the Sixth Amendment, appellate court considers the following: the length of the delay, the reasons for the delay, whether the appellant made a demand for a speedy trial. See, they're counting on you to demand it. But if nobody's telling you, and nobody's telling you that, hey, if this doesn't happen within a certain amount of time, this case gets kicked to the curb, that's malicious prosecution. I mean, that's not only a fault of the state's attorney, but your attorney. That's ineffective assistance of counsel. I mean, when you prove ineffective assistance of counsel, you quite literally prove the ineffectiveness of the court. Okay, whether the appellant made a demand for a speedy trial, prejudice to the appellant. So nobody telling you, you not knowing, the groundwork, for a quick and speedy trial, the limitations, nobody demanded it. They're going to say, well, you had to actually, and your lawyer's not going to demand it. You got to pay some big bucks for him to open his mouth about your constitutional right to a quick and speedy trial. And of course, he's not going to answer that because you have a constitutional right to effective assistance of counsel, and that's described in the rules of professional conduct, and he won't even tell you that. Every lawyer I ever tried to speak to on that always got angry and walked away. Hey, that's your legal obligations, yours and the judge's, to see that that happens in court. How many times can a prosecutor retry a case? Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Arizona versus Washington, often known as, violating the double jeopardy clause if they do that, okay? So not only can you not charge a person twice for the same crime in court, taking back court over the same thing, but you cannot charge them multiple times for the same crime. Okay, that's what happened to me. I didn't sign a confession, so they said, okay, we're going to, instead of charging you for one, we're going to charge you for two. Beat the crap out of me again. I wouldn't sign the confession. They said when they bring the state's attorneys in, the state's attorney is going to charge me for more crimes. The state's attorney's office, the state's attorney came in, said, if you sign this, we're only going to charge you for 4 crimes. And I said, I'm not signing anything. I didn't do anything. So it's just going to get worse. When we get you to court, we're going to keep adding on charges until you sign the confession, or take a plea deal. This is a gift. It's going to get worse. And it did. But eventually the court heard my argument on violating the double jeopardy clause. And they didn't even accept my argument on the speedy trial. They limit themselves to what laws they'll use. They're very picky. Not all laws matter in a court of law. I mean, if the rules of professional conduct don't matter and the code of judicial conduct don't matter, what the hell makes you think your constitutional rights matter? But they will if you bring them up. You have to go on the record. In a trial, a prosecutor finishes presenting their case and the judge finds they have not met their burden of proof. The judge may dismiss the case even before the defense permits their side for insufficient evidence. Who decides if a trial is speedy enough? The Supreme Court. There's just not a simple, firm time limit for what is considered reasonable, and then anything after that is considered unreasonable. Does the prosecutor determine if a case should be taken to trial? However, they are not obligated to take every case to trial. Instead, they exercise what's known as prosecutorial discretion, the authority to decide whether a case to pursue and how to handle them. And they will take a case to court without probable cause. It's done far too often. And then they have people sitting in court waiting for a quick and speedy trial without telling them, hey, you have a right to that. And this is the groundwork, this is the law on a quick and speedy trial. And if we don't have you in that trial going by the set amount of times, we got to kick this to the curb. Serious people, if you know anybody that's going through this, talk to them about it. Show them the laws. Like I said, don't forget, you can cite those violations on a motion to quash, motion to vacate, motion to dismiss. I forgot, but there's more than one method, and you can also file violations against the judge and the lawyers and the Code of Judicial Conduct and the Rules of Professional Conduct for not informing you about this or making sure to see that this happens. But they'll say you didn't ask. But I didn't know. Simple as that. I didn't know. Nobody told me. Nobody brought this up. I'm not a lawyer. I didn't go to law school. Okay? That there is your defense. Okay, you didn't know all this. You found out from me, and you should actually be finding out from them. They're the ones that are supposed to be telling you. If you read the Rules of Professional Conduct and the Code of Judicial Conduct, you'll understand it'll tell you that in the preamble. How many times can a lawyer reset a case? So there's a lot of questions here that can be answered. The number of times a case can be reset depends on the circumstance. For example, the defendant has a court-appointed public defender. They can automatically reset the case 3 times. However, a criminal case attorney who you hire on your own can automatically reset a case 4 times. What is evidence without proof called? Circumstantial evidence, also called indirect evidence, does not directly prove a defendant is guilty. Instead, it's evidence of another fact that can lead or be misleading. Can somebody be charged with no evidence? A person may be charged based on the testimony of a witness or victim, even if there is no physical evidence. Testimony is evidence. Why deny a speedy trial? There are times when it is in the defendant's best interest to delay a trial date. For example, the defendant may be ill and needs to recover, or may give the attorney more time to prepare a solid defense. Okay, what happens if you're not indicted in 90 days? No, the case won't be dismissed if you are in jail and the case is not indicted within 90 days. You can get a PR bond, or if you are not retain a criminal defense attorney, yet I suggest you do soon. Which is ridiculous. Why aren't they indicting you? You have a right to a quick and speedy trial. But always push the effort for a quick and speedy trial. If you are in jail and the case is not indicted within 90 days, you can get a PR bond. And it says if you have not retained a criminal defense attorney yet, I suggest you do. I suggest you do so soon. So what happens if I'm not indicted 90 days after my arrest? It's not opening. Well, it really doesn't say much. Cases, 90 days arrest. Can the case be dismissed? I was arrested, charged with 10.7 grams of crack cocaine in the school zone. I arrested and released on bond in March 2012. I was indicted on August 24th, 2012. I don't know. Lack of diligence, I'll tell you that. And failure to expedite litigation. Those are rules in the rules of professional conduct that apply to the state's attorney's office as well. So their failure to abide by the rules is a reason why you didn't have a quick and speedy trial. What was the purpose of not expediting litigation? How is that diligent? How is that competent? These are questions you're going to have to ask yourself. How speedy is a speedy trial? Okay, so there's a lot of stuff you can ask yourself, but it says right here, dismissal is the only remedy for denial of a defendant's Sixth Amendment speedy trial right. And there was one video I did maybe last week or so, where the judge threw out a case based on this, and it was some guys that chased down a FedEx delivery driver because they said he was in the wrong neighborhood and they didn't want him there, and they chased him out and told him not to come back. They got arrested for pulling a gun, and the guy got out of the neighborhood safely, and then he got fired from his job because he didn't want to go back in the same neighborhood. But so they were caught dead to right, but they filed based on quick and speedy trial, and the case was dismissed. Okay, there's... Oh, it's gone. Okay, sorry about that. Okay, so this is what we're going to go over next, the rules of professional conduct. You know, these are the legal obligations of all lawyers and judges in every court. Okay, so the rules of professional conduct for lawyers outline the ethical standards. Remember, people ask me quite a few times, if they violate the rules, are they violating, the ethics? Yes. They said, just take it to the ethics commission, but there's no sense, because it's easier to get a cop to arrest a cop, or, hey, he broke the law, than it is for the ethics committee to admit that any violations of the rules or the codes is an ethics violation. But if you go through the code of ethics, you'll find that it will say that. You just won't get any lawyer or judge to say that. The rules of professional conduct for lawyers outline the ethical standards that lawyers must follow. These rules including maintaining confidentiality, avoiding conflicts of interest, and communicating with clients. And I told you that's a rule in the rules of professional conduct. That is a law. It's not just a rule, it's a law. Those are the laws in the court of law. Those laws apply in every court. You don't do that, you broke the law. Lawyers must keep all information shared by their clients confidential, even after the lawyer-client relationship ends. They don't do that. That's the reason the judge had the sheriff beat the life out of me. My lawyer ran back and told her, he said, what can you do to change the judge's mind? I said, watch when I go back out there. He said, what can you do to change his mind? I said, reporting the rule of professional, reporting misconduct is mandatory in both the rule of professional conduct and the code of judicial conduct. He ran out there and told the judge, and the judge had the sheriffs, instead of bringing me out to court, take me back to the county jail and leave me for dead. Conflicts of interest. Okay, communication. Lawyers must keep the client reasonably informed about their matters. Lawyers must promptly comply with reasonable requests from the client for information. Other rules. Lawyers must conform to legal requirements. Lawyers must use legal procedures only for legitimate purposes. Remember I talked to you about slap suits. Sometimes they'll file paperwork just so you'll have to go get a lawyer to answer, and there's actually no legitimate cause or purpose. They have nothing to prove. Okay, so that's, and in the preamble clearly states it's strictly forbidden to file any frivolous or fraudulent claims. But they'll do it anyways. And then you'll have to get a lawyer, and then your lawyer will go in there and battle with their lawyer, and they'll take a long time, with their theatrics to make you believe that they're fighting something that there's no argument over. They shouldn't be doing that. Okay, that's deprivation of rights under the color of law. That was clearly under the color of law. Model rules of professional conduct. That's what we're going to go over next, okay? And I just want to teach you how easy it is to use. Okay, once you read it, study it, learn it, like I did, I always say it's easier to print out a copy and highlight every issue, so that way you can cuss and bang on the table or whatever while you're doing it, to get some of that energy out. But go through the whole thing thoroughly. I rarely get anybody that ever does that. They go, yeah, not all of it, but and I said, no, we'll have this conversation after you go through the rules and the codes. Yeah, but let me ask you a question about this, and then it always goes back to the same thing, and then I wind up citing the violations of the Code of Judicial Conduct, or citing the violations in the rules of professional conduct. I didn't know that. Well, if you read the rules or the codes, you would know that. That's why I keep saying, read the rules and the codes. Well, let me ask you, I promised myself no more phone calls. I'll just read the rules, the codes, all the laws, and then instead of asking me questions, you go on the internet, look it up, and then go back to court and ask the judges and the lawyers, because people tell me, why I got to know this if the judges and the lawyers know this? Well, if you don't know this, they're not going to do it. I keep proving it over and over, time and time again. And people get mad at me because of the broken system. The system wouldn't be broken if everybody just abided by the rules, the codes, the law, went by the letter of the law. Some argue, well, the spirit of the law. No, the spirit of the law basically is truth, justice, in the interest of justice. And the letter of law just clearly states everything must be done word for word to the letter, so that way we all hear, see, and say the same thing. People like to say, oh, that doesn't mean what you think it means. But the letter of the law clearly states it means exactly what you think it means. Okay, we're going to go over that. But there's a lot you should consider, and my best advice to you, is my best advice to me. Never walk into a courtroom without the rules or the codes. And go over it with everybody in the courtroom. Once you read the codes and the preamble, it says the judge has to give you time to speak your piece. He's going to talk to your lawyer. Your Honor, I want to discuss the rules of professional conduct and the Code of Judicial Conduct to make sure everything is by the book. I don't want to leave here or go through or have any deprive my constitutional rights. Oh, sorry, people. I don't want to have to go through this deprived of my rights under the color of law. Okay? Because that's no matter what case you go, you're always, if you don't state your rights, if you don't bring the rules of the code, so that way, due process plays out like it's supposed to, so that way you get a fair trial. Yeah, so anyways, like I said, in my next video, I'm going to go over the rules and the rules next, and then I'll go over the codes to show you how. It's literally impossible to violate one rule, and it's literally impossible to violate one code. It's literally impossible to violate the rules of professional conduct without violating the code of judicial conduct. It's literally impossible to violate the code of judicial conduct without violating the rules of professional conduct. It's a symbiotic relationship, okay? You can't damage just one part, you know. So when you start doing this, it'll literally take the domino effect, okay? You know, I mean, you cite your lawyer for ineffective assistance of counsel, state's attorney for prosecutorial misconduct, and the judge for judicial misconduct. Everybody's supposed to report each other for all the violations of the rules and the codes, as well as themselves. It's mandatory to report misconduct, and failure to report misconduct is misconduct. End of story, okay? We'll get into that soon. Thank you.